Hello, everybody. So I'm
Hello.
Shara. Hi. Hello, this is Gang AmerBON. So our speakers today will be Joshua Tay, New CMU, Michael Chia, Osulu, and Edmund Bon. Um, so, uh, what was on the news last week? It's the CMCO, and recently it's the raid by the Immigration Department in Masjid, India, um, to arrest illegal immigrants. So today, Josh will be talking about the disparity of sentence to those who are charged in court for breaching the MCO. And Mike will be talking about the ongoing issues, ongoing employment issues, basically like salary deductions, and so on and so forth. Sue will be talking about the latest immigration issues and also the recent raid in Masjid, India. And CU will be talking about the state and federal conflict regarding the CMCO. So, Joshua?
Okay, yes, thank you. Again, I will just speak in Malay for the benefit of viewers uh, who is more familiar in Malay, in the Malay language. Jadi hari ni saya nak mengulas sikit lah pasal hukuman yang telah diberikan kepada individu-individu yang telah dituduh di mahkamah kerana telah melanggar PKP. Dan kalau kita sebenarnya banyak berita atau artikel-artikel berkenaan individu yang telah dituduh lah pasal pelanggaran PKP ni. Saya cuma nak tunjuk beberapa contoh. Can I share my screen? Yes. So kalau kita lihat di sini ya, seramai 18 individu telah dituduh dan diarahkan untuk menjalani pemenjaraan selama 6 hari dan denda 1,000 setiap seorang kerana menghadiri upacara pengebumian di Klang. Dan contoh satu lagi, di Taiping pula ada 2 orang dituduh dan kerana menangkap ikan telah menangkap ikan, dan di sini dinyatakan mereka menangkap ikan untuk mendapatkan ikan sebagai makanan dan tidak mempunyai niat untuk menjual ikan. Jadi tangkap ikan untuk makan lah. Dan ini mereka telah dipenjarakan selama 3 bulan. Saya rasa ini adalah salah satu hukuman yang paling tinggi lah berkenaan pelanggaran PKP. Dan kemudian di sini kita lihat seorang ibu tunggal. Ini lawyer lah, ini bukan ibu tunggal. Seorang ibu tunggal telah dituduh dan dijatuhkan hukuman 30 hari penjara kerana telah melanggar PKP. Dan ini pula salah satu kes yang agak viral lah. Girlfriend hantar kek birthday kepada boyfriend, kemudian ditangkap polis dan dituduh. Dan girlfriend tersebut telah dipenjarakan 7 hari dan denda 800. Kemudian terdapat pula lain-lain contoh macam ni. Timbalan menteri dituduh dan dikenakan denda sebanyak 1,000 saja. Jadi ini dia makan dengan ramai orang tapi tak ada penjara, cuma kena denda. Dan ini yang paling latest lah, paling baru. 5 hari bulan jam 11. Jadi anak kepada Datuk Seri Zaid Hamidi dituduh di mahkamah dan didenda sebanyak RM800 dia dengan suaminya kerana telah melawat beberapa menteri lah. Ni di sini dinyatakan beliau melawat Religious Affairs Minister dan Deputy Environment Minister. Ya. Ni dia melambai-lambai. Okey, jadi di sini kita boleh lihat ya beberapa trend yang berlainan lah berkenaan hukuman individu-individu yang telah dituduh di mahkamah. Dan sebenarnya saya cuma nak ulas sikit lah. Saya nak ulas sikit berkenaan sentencing ya, atau hukuman yang dikenakan oleh mahkamah. Jadi secara amnya mahkamah mempunyai budi bicara untuk menjatuhkan hukuman sekiranya seseorang itu didapati bersalah melakukan kesalahan. Dan dalam undang-undang prinsip undang-undang lah dalam melaksanakan budi bicara mahkamah dalam menjatuhkan hukuman, mahkamah perlu mempertimbangkan of course prinsip undang-undang yang sedia ada dan faktor-faktor mitigasi. Faktor mitigasi ialah faktor-faktor yang dihujahkan oleh sama ada peguam bela atau tertuduh sendiri untuk cuba mengurangkan, untuk merayu kepada mahkamah untuk mengurangkan hukuman ya yang akan dikenakan. Kemudian juga yang ketiga, mahkamah perlu mempertimbangkan faktor pemberatan. Ini akan dihujahkan oleh pihak pendakwa raya ya untuk memohon supaya hukuman yang lebih berat dikenakan terhadap seseorang tertuduh. Ya, dan ada kalanya terdapat juga situasi di mana mahkamah perlu mempertimbangkan statement, pernyataan daripada seseorang mangsa kepada sesuatu kesalahan. So sekiranya mungkin mangsa ragut, ya, dia kena ragut dan tertuduh tu kena dihadapkan di mahkamah dan didapati bersalah. Jadi mangsa tu pun boleh memberikan pernyataan lah di mahkamah untuk sebagai salah satu faktor pemberatan atau faktor untuk mahkamah pertimbangkan. Tak semestinya faktor pemberatan lah, sebagai satu faktor untuk mahkamah pertimbangkan. Ya. Dan kalau kita lihat pada tadi artikel-artikel yang telah saya tunjukkan, ya, saya pun ada baca lah di social media, terdapat macam terdapat komen ya yang menyatakan bahawa nampak macam ada timbulnya persepsi ketidaksamarataan di antara politician, VVIP ya yang hanya dikenakan denda dan lain-lain golongan masyarakat yang adanya dikenakan hukuman penjara. Ya, dan yang paling baru yang berkenaan kes di Taiping yang berkenaan 2 orang yang telah ditangkap dan dituduh kerana memancing ikan ya. Di sini dan kes ibu tunggal ini, kedua-dua kes ini telah disemak oleh Mahkamah Tinggi ya. Jadi untuk kes ibu tunggal ni hukuman pemenjaraan telah disemak dan ditukarkan kepada 1,000 denda. Dan bagi kes yang tangkap ikan di Taiping, mahkamah telah mengenakan perintah untuk menjalankan khidmat masyarakat. Saya tak pasti sama ada ditulis di sini. Jadi dalam kes tangkap ikan tu sebenarnya Mahkamah Tinggi Taiping ada menulis alasan penghakiman lah yang saya rasa amat berguna bagi Mahkamah Rendah, di mana Mahkamah Tinggi menyatakan bahawa sebenarnya dalam menjatuhkan hukuman, Mahkamah perlu menimbangkan pelbagai faktor dan Mahkamah juga mempunyai pelbagai alternatif atau option selain hukuman pemenjaraan. Dan bagi saya, pendapat peribadi saya, hukuman pemenjaraan tu tidak sesuai lah untuk semua situasi. Kerana ia juga boleh meningkatkan risiko jangkitan bukan saja kepada seseorang tertuduh itu, tetapi juga kepada banduan lain ataupun kepada kaki tangan kerajaan, polis, kaki tangan mahkamah dan pegawai penjara yang juga akan terdedah kepada risiko jangkitan. Dan terdapat juga situasi seperti mungkin seperti yang kes tangkap ikan tu, hukuman denda juga mungkin tidak sesuai bagi kes tersebut kerana sekiranya seseorang itu kurang berkemampuan dan tidak mampu membayar denda, secara lazimnya apabila mahkamah menjatuhkan hukuman denda, mahkamah akan juga memberikan perintah bahawa sekiranya gagal membayar denda, pesalah tersebut akan dikenakan hukuman pemenjaraan. Jadi kadang-kala bagi orang yang kurang berkemampuan, mereka tidak boleh membayar denda atau tidak dapat membayar denda, mereka akan dihantar ke penjara. Jadi itu juga tidak terdapat kadang-kala itu juga tidak sesuai lah, terutamanya bagi kes seperti yang tangkap ikan di Taiping tu, mereka tak dapat bayar denda, jadi mereka minta hukuman pemenjaraan, dan mahkamah menjatuhkan 3 bulan penjara. Jadi dalam kes tersebut, Mahkamah Tinggi Taiping menyatakan bahawa telah memberikan dua lagi alternatif, iaitu salah satunya ialah perintah binding over atau perintah untuk mengenakan bon kelakuan baik. Tetapi mahkamah berpendapat dalam kes itu bahawa tak wajar kerana bon kelakuan baik tersebut tidak akan memberikan pengajaran yang sewajarnya kepada tertuduh. Jadi mahkamah sebaliknya mengenakan perintah khidmat masyarakat. Jadi saya rasa perintah khidmat masyarakat tu sebenarnya salah satu option lah, maybe one of the best option untuk hukuman, sebagai salah satu bentuk hukuman bagi pelanggaran MCO, kerana ia bukan saja salah satu one of form of deterrent, tetapi juga ia boleh memberikan pengajaran lah kepada seseorang tertuduh. Dan walau apapun, saya rasa kepada penonton-penonton lah, saya punya nasihat ialah cuba untuk patuhi PKP sehingga setakat ini tarikh luput ialah 12 Mei kan, 12 Mei. Jadi cuba patuhilah PKP dan kita perlu ingatlah berkenaan bagi individu-individu yang frontliner, yang seperti polis, doktor, jururawat, tentera, mereka they have no choice. Mereka tak ada pilihan, tapi mereka bekerja dan mereka juga mendedahkan diri mereka kepada risiko jangkitan, dalam usaha untuk menangani wabak COVID-19 ini. Okay. Setakat ni itu sajalah. Saya rasa saya pun dah cakap panjang 15 minit. Saya beri peluang laluan kepada peguam-peguam lain untuk memberi ulasan berkenaan isu-isu lain. Okey. Terima kasih.
Okay, terima kasih Joshua. Jadi pengajarannya kalau nak jumpa boyfriend, nak pancing ikan pun hukuman berat lah. So kita perlulah patuhi seterusnya. I will proceed with the very famous employment issues of salary deduction. So Michael Chia will address this issue.
Hi everyone. Hello. Hi. I'll be addressing the employment issues recently on salary cut. So we've been receiving questions from people, especially in the legal industry, who have been asked to take a salary cut. Okay. For this, I'll address it in two parts. The first part is, if the salary cut is imposed on you without your consent and you do not agree to it, you have the option of terminating your employment and citing constructive dismissal. Remember that one of the few important elements of constructive dismissal is that there must not be any delay. If you delay, it can be seen as that you have accepted the breach and that you have accepted the salary cut. So what you can do after terminating your employment and citing constructive dismissal is that you can lodge a complaint to the Director General of Industrial Relations under Section 20 of the Industrial Relations Act for wrongful dismissal at your local Department of Industrial Relations. Okay, there is no limit for those who are considering this option. Okay, there's no salary limit, so anyone also can go for this option. Okay, so the second option is strictly for those who earn between 2,000 ringgit to 5,000 ringgit. You can immediately lodge an official complaint under Section 69 and Section 69B of the Employment Act 1955 to the Director General of Labour, but at your local Department of Labour. So in this case, there is no need for you to terminate your employment and cite constructive dismissal. You can immediately do it on your salary being deducted or whatever or when your salary has been unilaterally deducted. Okay, so these are the two options that you have. The second part, which I'll be addressing, is where we have also been informed that employers are also offering pay cuts packages between 20% to 85% of their monthly salary. What we see from these inquiries that we are getting are that some employers are doing it in good faith, trying to maneuver through these difficult times, okay, through this loss of income and trying to mitigate this loss of income that their firm or their company is having. While at the same time, we also see employers who are taking advantage of this situation to reduce their costs. Okay, and what they do is they try to cut down the salary of almost everyone, and sometimes maybe forcing them to leave the company. So what usually they'll do is they will give you the option and make you agree to it. Okay, they make you agree to it. So, but what you should do is you should first try to negotiate it, but negotiate it in numbers so that you don't go alone, but you go with more of your peers so that you have a stronger bargaining power. Because at the end, eventually, if you agree to the pay cut, you will not be able to, or it will be very difficult to argue constructive dismissal. All right. Also, I would like to also note that if to be cautious, that if the amount that you're getting after the supposed pay cut that you're supposed to get is below the minimum wage, then that is not permissible. Okay. So at the end of the day, you must know that when you get the pay cut, the minimum wage, your employers must still adhere to the minimum wage. It does not mean that when you get a pay cut, they can cut you until your salary goes below like 1,000 ringgit. No, that is really unfair. Okay, so I would like to just address. I forgot to say something a bit earlier when regarding the option of constructive dismissal. Is that you can go once you have lodged a complaint to the Director General of Industrial Relations, there will be a negotiation and reconciliation process done between the employer and employee. Okay, so that one you can represent yourself. You can go there and negotiate to try and reach a settlement. All right. If a settlement is not achieved, then the minister, the Director General will refer the case to the minister, and minister will consider whether to refer it to the industrial court. Based on Pakatan Harapan's policy, any cases which is being referred to the minister would automatically go to the industrial relations court. Go to the industrial court. Okay. So at the industrial court, what can happen is once your case is being litigated at the end, if you are successful in constructive dismissal, you will be allowed. I mean, the industrial court can award you back wages and also reinstatement in lieu of reinstatement in lieu damages in lieu of reinstatement. So these are the options available for you if the situation arises where your employer has offered you a pay cut or has unilaterally imposed a pay cut on you. So yeah, if you have any queries, please do not hesitate to ask in the comment section, and then we'll try to address it later in this talk. Thank you.
Thank you, Michael. So I think employees have to bear in mind about the minimum wage when it comes to salary deduction. So next on, we will move on to Sue, who will be talking about the recent immigration issues and the illegal raid in Masjid India. So proceed, Sue.
Hi. So after our chit chat last week, there's still similar news on foreign spouses and children without the long-term social visit pass they are still barred from entering to Malaysia. So it was still reported last week. So now in view of the current Conditional Movement Control Order, for those who have a valid pass other than the long-term social visit pass and wish to enter into Malaysia, our advice is that you can write to the immigration department explaining your circumstances and situation and ask an answer from the immigration as to can you re-enter Malaysia during this CMCO. So another point on this issue relating to the prohibition of entering into Malaysia is that we noticed that the FAQ issued by the immigration department is not gazetted. So technically speaking, it's just a guideline. Although saying that by law, the Director General of the Immigration Department do have the power to prohibit entry of foreigners, but the law is clear that the prohibition is not applicable to those who have a valid pass or valid pass, valid permit, or valid visa holder. So for what the immigration should do is that they should actually not they should do like what usually they do from prohibiting those who have a valid permit or valid visa to enter into Malaysia is that they would usually suspend or cancel the visa and pass. And if they actually do so, they will issue a letter to you stating that your visa is cancelled or suspended. So technically speaking, for them to prohibit those who have a valid permit or visa holder to come into Malaysia, it's not right for the government to do so. So on this issue, it is open for legal challenges lah. So that is on the recent immigration issue that appeared last week. Another issue that was reported in the news is that there is this immigration raid in Masjid India, and the justification given by the government for this immigration raid is that they round up the migrants is to contain the COVID-19 virus. But the thing is, the government during the beginning of the MCO has reassured the immigrants who believe that they have the coronavirus. They told them you shouldn't be scared and you should come to the authorities and have it tested. And then our defense minister actually said that they won't focus on their documentation, but rather they are positive on the COVID-19. This is to encourage them to actually come forth and have them check whether they have the virus. But then on 29th of April, the government made a U-turn and they suddenly announced that all the undocumented migrants in the red zone across the country will be placed in detention center or special prison gazetted by the Home Ministry. And then after that, on 1st of May, they conducted a raid on the illegal immigrants, namely in the Masjid India area. So migrant workers are already discriminated in Malaysia. They are like always being looked down, already like unfairly targeted by most of the public in Malaysia. So with this rate, right, it will actually further discourage migrants to come out to take the test. Like maybe they might want to come out and take the test, but because of this rate, they don't dare to come out and they hide in further in their house or something like or and that. And so like what I think is that the sudden change of stance in relation to the sudden change of stance and the sudden U-turn by the government is because of the increasing hate speech towards refugees and migrants in the online. So maybe that's why what the government did now is that they have committed to promoting a policy of fear and xenophobia, and then this one actually transferred the Malaysian public anger onto the foreigners who cannot defend themselves. So what I think the government should do is to reflect on why the migrants are actually undocumented or became undocumented. It's actually back to the governments themselves. It's their poor implementation of recruitment policies and that their poor enforcement against recruitment agents and employers who exploit the workers. So the person that the government should go after is actually the agents and the employers and not the employees who are the migrants who are being brought to Malaysia by being promised by the agents or employers that they'll have a secure job. So those who actually cause issues of this is actually the employers and the agents. So I think the government should really look into the policies in that. And that's my view, and that's my view for today. If you have any questions or comments, you can just let us know about this. Thank you.
Sarah is hung. So we can pass it on to Sinyu.
Hello, hi. I'm going to speak about the restrictions that has been imposed by some state governments despite the MCO being relaxed on businesses. So I think a few days ago announced that despite there's now a CMCO and most business operations are allowed to resume as usual. There are some restrictions that has been imposed by these states because they are still afraid that it's not safe enough for businesses to resume. And there's been, I think, some press statements from ministers, including Azmin, saying that the states should follow what has been decided by the federal government with regards to the CMCO and not impose their own restrictions, because if they do decide to impose additional restrictions, what's going to happen is that certain businesses would decide to take legal action against these states. So there's a bit of confusion as to whether or not these states can lawfully impose additional restrictions on these businesses with regards to their operation. Some legal experts have said that no, the states cannot do so. I, however, take a different view because when it comes to, if you look at the wordings of the latest regulation under the Prevention and Control of Infectious Disease Act, this regulation number 5, you would see that the regulation provides for certain prohibited activities. What the regulation doesn't say is that businesses must open. So you fall back to the default position that if businesses are no longer a prohibited activity, they are allowed to open. But whether or not to open, it's really up to all these businesses. And if they do decide to open, the usual requirements for operating a business would still have to be complied with. And that includes state restrictions or state conditions. And the states can lawfully impose restrictions or conditions to these businesses that are operating within the state. And I think this is quite clearly spelled out in the federal constitution. If you look at the state list and you look at item number 5, it allows state to impose restrictions on services, except for those listed services they are under. But those are normally services which would have implication on public health, like burial grounds, funeral parlors. And another consideration that we need to take into account is that when it comes to matters of public health, states, they have a say in it, because public health is an item under the concurrent list. Concurrent list simply means that when it comes to any items on this list in the federal constitution, 9th schedule, both federal and state have a say in it. So states imposing restrictions on businesses, to me, is perfectly lawful, is not inconsistent with the latest regulation by the government, as may have been suggested by some officials, because the regulation is worded in the negative. So once businesses are allowed to open, they must comply with state restrictions. That being said, businesses should also, they may want to consider this. And that is, if the federal government has decided that, okay, it's already safe enough to resume operations, and there are some operations in some states where the CMCO is relaxed and there's no additional business restrictions, they would be discriminated because businesses in other states are allowed to operate, but not businesses in the states they're operating in. So that's something to consider. Of course, whether or not they would be successful, I think that really would depend on the nature of your business, how risky it is to public health, and whether or not the businesses in other states they operate under a similar condition where there's perhaps less red zones in those particular states. So I can't provide you with a yes or no answer, but these are the things that you might want to consider if you are so dismayed or so aggrieved at the decision by certain states to impose additional restrictions on your business. I think, yeah, that's pretty much it.
Thank you, Sinyu. So I'm pretty sure everybody is confused about the CMCO lately, but I think it's pretty clear that there are guidelines that needs to be followed. So next off will be admin, who have probably a few words about the recent MCO. Please, admin.
Thank you, Shara, and hello everyone. This is my first time here. I think we wanted to do this to try and give some practical advice to people who need help. And thank you for all your questions. We try and deal with them as best as we can. But I think today, for a short while, I want to zoom out a little bit to a bigger picture. And I think this is something that has not been discussed very much in society. We look at how power is being used by government during the MCO. We looked at when Joshua talked about the judiciary, mahkamah, how there is some sort of double standard. Mengapa terdapat denda hanya terhadap anak Zaid sebagai seorang ahli politician, tetapi bagi golongan miskin mereka perlu dipenjarakan. So there's some sort of double standard and unfairness there. Michael talks about employers and employees. Why suddenly law firms and why suddenly big corporations want to deduct wages of employees who have been working very hard for you, suddenly disguising it and then saying, look at these three options, can you pick one? And then when you decide to pick one, you are gone. You have no more legal rights because you've accepted a reduction in your salary. Suddenly, because of the MCO, 1.5 months, you suddenly say, oh, your business is closing. Again, there's that inequality. Again, there's that power relation. And then Sue talks about immigration rates. When you have vulnerable, undocumented migrants ready, you go there and raid them some more, and then you try and ask them to leave the country or deport them and put them in immigration centers. When the root problem has always been, and the NGOs have always been talking about how recruitment agents have been pocketing and making a lot of money. Where are they now? Shouldn't they be the ones that are forking out to be paying for the migrant workers when they have benefited from them? Why are big corporations and employers now saying, oh, please make sure that the migrant workers stop coming, when they were the ones that they wanted the cheap labor? Again, you see there's a class inequality, a power relation. And I think the idea about this chat or this legal aid clinic was to try and highlight some of the problems on the ground, but also look at how we are treating society. I think when you look at income inequality in Malaysia, it has grown. The figures that I've seen recently from 1970 to 2016, although the average top 20% earners in Malaysia, the income fell from 9.6 to 5.6 times the average income of the B40 and the M40. However, the gap has increased in reality. In 1970, the gap was 3,200. Today, the gap is 13,200. So what it means is that the rich top 5%, top 20 are earning 13,200 in that sense, and the lowest bottom 40 are only earning 3,200. There is that huge gap that has increased in Malaysia. And now you see government suddenly wanting to become a big government. Whether you call it socialism, whether you call it increased social protection, whether you call it prihatin, the pandemic is a challenge against capitalism. It's COVID against capitalism. It's COVID against neoliberalism. We have always focused about economic growth. We have never talked about proper social protection policies for the B40. We give out little bit based on prihatin. We give out little bit based on how families live, how households live. But why are we not looking at a proper system that covers everybody? Migrant workers, informal sectors, those people who don't have wages and salaries on a consistent basis. COVID has also increased the problems in households. We have not calculated how much your mom, how much your domestic helper has now increased their workload because we are staying at home. We do not account for those things. And what we are talking about now, and I think what I am trying to say is that it is time to look, it is time to start looking at how we should change the way we do business in Malaysia. It's the privatization of public goods, privatization of your water to make money, privatization of housing to make money. More importantly, privatization of healthcare. I really want to thank the health liners, the frontliners and the health workers in the Ministry of Health and all the hospitals who have been putting their lives out there for all of us. We really appreciate that. But if Malaysia didn't have a strong governmental system of healthcare, or somewhat a universal healthcare system, we would not be able to treat the problem properly. In America, where you have privatized healthcare, when you go to hospital, you need to make sure you have insurance. And now even medical insurance policies do not cover COVID because no private hospital can treat COVID. Where are those insurance companies? Why are we being asked to buy insurance for healthcare? Why are doctors charging so much? Why are people making money from healthcare? Why are people making money and making us buy insurance for healthcare? What I'm trying to say is that because we have that kind of social protection system, we have a fairly good healthcare system. Government should be looking at spending more money on public goods. Stop privatizing public goods. Stop privatizing the roads. Stop privatizing water. Stop privatizing railway services. Emphasize these things that allow for greater resources to be put into these public goods. And COVID is that challenge. COVID is not just a challenge on our life expectancy or mortality. COVID challenges the way we do things in the future. I hope we are not going to go back and say, okay, everything is the same. Everybody talks about a new normal. But do you think the big corporations, do you think the big law firms are going to keep doing the same, keep going to continue? Or are they going to say, oh, sorry, I have no work, when actually the savings from all the profits they have made is just reduced, and therefore I need to cut your salary? The income inequality, the power relations has shown that the people in power, and power is diffused this way. Power is not diffused just in imprisoning people or putting them into jail. Power is diffused in these ways where it's unseen. And we need to look at that kind of power. We need to continue to resist and challenge that power. We cannot give in to that power. And I think we look at how, we are treating refugees, we are treating migrant workers, we have different sources of information giving us different signals and different messaging. And I think that sometimes angers some of us because, as lawyers, we are trying to be out there, trying to help as many people as possible. But then when law firms, I hear, are cutting 10, 20%, 80% of salaries, look, you are a conveyancing firm that has made so much money from banks. You give discounts on your conveyancing files. You give letter of demands for 5 ringgit. And then you have to have large numbers of staff to make sure you process all the work from the banks. They are the ones that made your profits. Now you are saying, oh, let's cut 80% of the salary. Are you looking at yourself, or are you actually looking at saying, okay, the staff are not so important? So all the glossy magazines or the big GLCs or the big companies say, oh, the staff are very important. They are the ones that tore the fuse. They are the ones that come up with our produce to make money, right? Who are the first ones to be affected? The workers. How can that be? Because the system, the way we are thinking only about economic growth, and that's how neoliberalism has got us here, is like a deck of cards. When one stops, it's like a domino, everything drops down. I think that's all I want to say for the moment, but it angers some of us because we have been in the profession for 20 over years and we see how it's done. It's not the best. We try and change things. We try and close the income gap. But then suddenly with COVID, 1.5 months, Bar Council, Sinu is on the Bar Council, right? Suddenly, wow, short while, oh, please give us some more money. We have always asked government to deregulate the industry. Businesses have made profits from deregulation. Suddenly, everybody wants a bailout. When you have made so much money, suddenly, please, government, I want you to be a big government suddenly. Just because there's COVID. Because big corporations and big companies have never really thought about social protection, have never really thought about how to closing the income gap. And then now you see the impact. You see the income inequality in the courts by way of disparity in sentencing. You see employers trying to cut 80%, 90% of salaries. That's crazy. It's constructive dismissal. There should be a whole lawsuit when people do that. And Sue talks about the immigration the already discriminated, you have multiple discrimination on the already discriminated. You know, it's crazy, and these are things which, yes, the government has done quite a lot. And remember, what the government is doing is not things a capitalist government would do. What the government is doing is actually adopting a big government type of policy where you give out and give and give and give. So when you talk about socialism, when you talk about the left, when you talk about, yeah, can you stop doing all these things, right? You are actually having a government trying to keep up with the different inadequacies of our system. Thank you, Cheryl.
Thank you, Edmund. So yeah, wide range of issues that everyone should think about, and probably, you know, think about it before you go to bed. So we have an employment question. It's in Bahasa, so I'll read it out in Bahasa. And here goes. So ini meraih satu kontrak pekerjaan di mana pekerja diambil kerja untuk bekerja beberapa bulan dan syarikat kata akan disambung kontraknya selepas beberapa bulan itu. Tetapi syarikat sekarang kata tidak boleh teruskan kontrak. Okey, pekerja kata kerjanya masih wujud tapi syarikat mahu buat pengurangan pekerja dan pilih dia atas kontrak tetap ini. So adakah kes ini boleh dismiss atas alasan fixed term contract? Maybe Michael, can you answer this question?
Hi, okay, I'll answer this question. On the face of it, I don't think the industrial court would straight away dismiss this case because the industrial court recognizes cases where, because the industrial court recognizes fixed terms contract, okay, which are genuine and which are not genuine. Okay, for fixed terms contract, for a genuine fixed term contract, it is the court will have to look into whether the fixed term contract is a genuine one or not. Okay, whether it's a genuine fixed term contract or whether it was meant to be in a permanent nature. Okay, so what is a fixed term contract then? It is especially when both parties to a contract between employer and employee understands that the contract will not be renewed. Okay, for example, of such contracts would be like performance of seasonal jobs, like plucking fruits during a certain season, or for example, if they are project based. So after at the end of the project, that's the end of the contract. If it's a genuine fixed term contract, then yes, probably the industrial court would dismiss the case because the employer was right to not continue with the contract. But if it was a case where, you know, throughout the employment during the fixed term employment, there were promises made that, you know, he can continue, he will be renewed, you know, or he has terms in his employment contract which looks like which grants him, how to say, benefits of a full-time employee or permanent staff. Okay, so these are the factors that the court will look into, and the court also look into the full circumstances of the case and the relationship between the employer and the employee, whether it was actually meant for a fixed term or whether it is a permanent contract but disguised as a fixed term. Okay, so if it's disguised as a fixed term, then the industrial court has the power, and the failure to renew the contract at the end of the fixed term, so-called fixed term, that can be treated as wrongful termination. So then, what the industrial court can do is the industrial court can award back wages, and like I mentioned earlier, back wages, reinstatement, or damages in lieu of reinstatement. So these are the options that can happen. So looking in your case, I think you need to look at the whole circumstances of the case, and see, and I can't give you a direct answer whether the court will dismiss or not, but these are the factors that you may have to look into. Okay, so another factor that you have to look into is how many times has he been renewed. How many times has his fixed term contract has been renewed and all the all other factors which I've mentioned earlier. So so it's not clearly doesn't mean that the court would immediately dismiss when your contract is termed as a fixed term contract. The court will have to look at whether the fixed term contract is genuine or not first. Okay, so I hope that helps. Thank you.
Thank you, Michael. The next question is, how do I go out for dinner with family of four when MCO only allows two out? I think recently there's a newspaper article saying that in a car there can be 4%, the driver and 3 passengers. However, I think these guidelines can be found in the Menteri Keselamatan website. However, I think Malaysians should have social responsibility, and at this stage, the number of positive cases is still increasing. So it's still a CMCO, and I think now social responsibility is also very important that Malaysians should be taking into account or should, practice. Um, so that's my answer for that question. Next, I think I will let Amir say a few words. Amir?
Hi, thanks, Shira, and hi everyone. I just want to share a bit and talk about one other recent issue which had dominated the limelight recently. This is in relation to the plight of refugees or asylum seekers who tried to seek shelter in Malaysia. As it is, Malaysia is not a signatory to the 1951 to the UN Refugee Treaty. Having said that, in terms of practice, Malaysia has always given some sort of protection to asylum seekers. We can see from the Vietnamese boat people in the 70s and the 80s, and then we had the Aceh conflict where Malaysia had received and given some sort of protection to Achenese refugees, and then we have recently the Rohingya issue. Even though our law, in particular immigration law, does not provide any mechanism to recognize or to process or to deal with refugee. However, in terms of practice, we have been allowing them to remain in Malaysia and to a certain extent maybe to seek employment. Malaysia has been working closely with UNHCR on this issue. I mean, that is something that we have to accept and recognize. But what is a bit more worrying is that we could see the trend of xenophobia. We can see a lot of hate campaigns, petitions being circulated, asking for them to be sent back, and I think there are some extreme calls asking for them to be cleansed from Malaysia, some sort of ethnic cleansing. Let's appreciate that first and foremost, we are all human beings. We all have certain basic rights, even though we do not have proper law to regulate asylum seekers and refugees, but they should not be treated in a very inhuman way. Now, one of the concerns that the public had expressed, I mean, those who are against the receiving of refugees into Malaysia, is that they said, they are creating problems and issues to the society, to the community. Receiving asylum seekers or refugees doesn't mean that they are immune from the laws of the land. So if there are those group of those asylum seekers or refugees who had flouted Malaysian laws, they should be dealt with according to the laws of Malaysia. But what we should not tolerate and what we should not encourage is this xenophobia, saying that, look, they should not be treated with humanity, with compassion. Currently, we are dealing with the COVID-19 situation. So a lot of people are concerned about the spreading of the virus through these migrant, through these asylum seekers and refugees. This is where we need to come out with a proper and permanent solution to this refugee problem. Perhaps there should be a designated area where they could be kept and they could be checked, they could be screened, and they could be processed to be repatriated to a third country. So some sort of mechanism have to be looked into. This is not a new issue. This is not a new problem. This problem had been going on for years. A lot of big organizations, big institutions, or have resorted or had used asylum seekers as workforce. And when they have problems, they will just let them go, because why? There is no proper documentation. So you can see there's some sort of abuse going around at the same time. Without dealing this issue on a proper basis, we're going to encourage more human trafficking problem. So whether we like it or not, in order to curb human trafficking issue, we need to have a proper structure that will deal with asylum seekers and refugees issue. Another issue that we need to appreciate that not all asylum seekers are migrant workers. Asylum seekers had to leave their countries because they could not seek protection from their respective governments. They've been persecuted, they're victim of persecution, as opposed to migrant workers who leave their country voluntarily, and they still could get protection if they go back to their countries. So there's a distinction that needs to be appreciated by everyone. I think that's all I want to touch about this issue. Thanks.
Thank you, Amir. Yeah, I think the asylum seekers and refugees are being treated very unfairly at this moment due to the spread of the COVID-19. Something to think about. Next, we have another employment question. It's an employment agreement. So I think everybody can see from the screen. I'll just read it out. Can the parties, more so employer, rely on frustration and rescind the contract without being liable to serve the notice period or pay salary in lieu of notice? Second, if notice is required to be served, then how may the employee can serve such notice, taking into account that current restriction and non-essential services? The above questions are on the assumption that they are non-essential service and CB restriction is extended further with no certainty. Maybe Steve, can you take this? Or okay, Michael, maybe Michael.
Hi. Okay. As whether employers can rely on frustration, it is to be borne in mind that there are elements to frustration before frustration can be applied. Okay, firstly is that the underlying event, which is the current pandemic or the current MCO orders being enforced, is not the fault of any party to the contract. Okay, so it's not the fault of the employer or the employee. Okay, that is understood. Okay, the event which is this MCO and COVID-19 occurs after the formation of the contract and was not foreseeable by the parties. Okay, that's another condition. The last condition is, which is the important condition which I would like to stress, is that it becomes physically and commercially impossible to fulfill the obligations set under the contract, or it changed the nature of the contractual obligation from that was initially agreed upon under the contract. So in this COVID-19 situation and MCO scenario that we are in now, it is the MCO merely restricts movement but does not prevent people from working. So technically, you can still continue to work. It's just how the employer allows you to work. All right. So this is not a situation where a frustration situation would come in times where there's a situation of war. For example, it's a prolonged war for a whole month, and it's not possible to work at all. So that's one contrast. That's one contrast of scenarios that I can give. Okay, so in regards to notice of termination, I think there is no set procedures in terms of labor law on how notice can be effected. So long as the employer has notice of the termination, that would be sufficient in the industrial court. That's all. Yeah, hope that answers your question. Thanks.
Okay, thank you, Mike. We have another question. The question is about a winding up petition. So this person asked whether she can file a winding up petition if she has issued the statutory winding up notice before the 6-month guideline was gazetted. Sinyu, can you take this question?
Yeah, Melody, if you look at the exemption order that was gazetted on 23rd of April, it says quite clearly that the notice of demand, which this order is applicable to, would have to be a notice of demand that has been issued from 23rd April until 31st December 2020. So if there was a winding up petition and the notice was issued before that, then it wouldn't apply. The normal, I think it was 21 days, right? The normal 21 days would be applicable. But just to add on that, that being said, there is some valid argument that that particular exemption order may be invalid because under the Companies Act, the minister is empowered to exempt some companies or some classes of companies. But this is an exemption order that is applicable to all companies. So there could be some argument as to whether or not the minister has acted beyond the powers that has been given to him under the Companies Act. There are a whole lot of other arguments as to whether or not this exemption order is invalid apart from the one I just said. But I think it's not necessary to answer your question. So yeah, it's not applicable, and you can file the winding up petition.
Thank you, Sinyu. So we have a follow-up question from the same person, Ashwin, who is asking about e-signature, whether you can use an e-signature, which is a digital signature, to attach to an agreement, but it is exchanged by way of email. So in short, yes, you can use e-signatures so long that it complies with the Act. So yes, we can use it. So that concludes our session today. We will have another chit chat next week on the 12th, same time, 12 o'clock. So Gang AmerBON will be still here next week. So stay tuned. Thank you. Bye.